Lutwidge against Lutwidge. Now, that having been said, the court held that the opening words used by the testator in that matter, they were essential. They were very essential in determining the testator's motivation. Now, the judge actually mentioned that, assuming that the word only stated that this is my last will and testament, it will have failed to be a sufficient, express revocation of that will. It will have failed in amounting to, sufficient express revocation of that will. Of course, Lagtan J held that the earlier disposition were revoked because burden of proving that the testator had actually intended to revoke them had been discharged due to the expression and the use of the word, I revoke my last will, I revoke my former will, and that will qualify as express revocation of that will. So the point I'm making here, the point I'm trying to make here is that when it comes to revoking a will by a subsequent will or by a subsequent codicil, you need to, and then you want to achieve an express revocation, you need to insert in that will what we call revocation clause, and that revocation clause will not saying that this is my last will, this is my last and only will not amount to revocation of that will not amount to express revocation of that will. But it would be nice if you follow the provision of section 20 and then you more or less insert in that will what will amount to express revocation. Example of what will amount to express revocation is to say that I revoke all former wills and testamentary disposition and declare this to be my last will and testament. However, when you talk about a case exemplifying express revocation of a will by express revocation of a will, you see the case of Lutwidge against Lutwidge, in which the testator mentioned that I revoke all former wills, this being my last will and testament. Court said that the burden of establishing that the will has been expressly the burden of establishing that the will has been expressly revoked has been discharged by the use of that opening word. So that is the important thing for us to note when we are drafting a will. Please, I need to charge this. Oh, I don't know what's wrong with this. Okay. So now it is also important. It is also important for you to note, very importantly, whether the testator has other wills in foreign jurisdiction. Please, as a lawyer and you are drafting a will, you need to note, you need to find out if your client as a testator has other wills in foreign jurisdiction. If the testator has other wills that are dealing with foreign property, then you must be very careful as a drafter to ensure that that will does not revoke any of the foreign wills. So what I'm trying to say here is that you don't just use express revocation generally. You don't just use it blanketly. What you do is that you need to be careful if your client has, a will in foreign jurisdiction. And what that means is that if the testator has other wills dealing with some foreign properties, then you must be careful to be sure that this will does not revoke any other foreign will belonging to that testator. Now, what do you do to ensure that you do not use this, express revocation to revoke foreign will or will dealing with other properties? Now, what you do is that you must put a standard revocation clause. I get to my point. Uh, what I'm trying to say, that if standard revocation clause were to be used, then all the foreign wills would probably, be revoked. So if you use this standard revocation that we have put here, that I revoke all my former wills and testamentary disposition and declare this to be my last will and testament, it would mean that it will revoke all foreign wills dealing with foreign properties of the testator. That standard revocation clause may not be applicable where you find out that your client who is drafting a will or who is a testator has wills in foreign jurisdiction, or he has properties dealt with by other wills in foreign jurisdiction. So what that means is that you as a drafter, you as a lawyer, you need to modify your revocation clause. You need to modify your revocation clause to suit the circumstance. And then what do you do in that regard? For example, you could want to revoke only, your estate, the estate of the testator kept in UK. You want to revoke only the estate of the testator kept in UK. And then the only way you can do that is to say, I revoke all earlier wills. I revoke all earlier wills to the extent that they relate to any part of my estate in the United Kingdom. I revoke all earlier wills to the extent that they relate to any part of my estate in United Kingdom, or it could be in USA, or both of them. It could be in USA, UK, Singapore, China, Japan, and rest of that. So what I'm trying to say is that you must be creative when you find that your client, who is a testator, is having a will in foreign jurisdiction, and that will is more or less dealing with some other properties in that jurisdiction. So what we're trying to say in essence here is that when you come to that, realization, you need to be, creative in ensuring that you save the will dealing with estate, in some other jurisdiction other than where you are operating. And an example of that is to say that where it happens that you want to revoke only the testator's previous will in respect of the estate, in respect of his estate in UK, you could state that I revoke all earlier wills to the extent that they relate to any part of my estate in the United Kingdom. So now it's also possible for us to say that you want to revoke all your will in any part of the world, except the one in France, except the one in France, or except the one in Australia, or except the one in Nigeria. I want to revoke every will, all wills that I've made in respect of my property, in respect of my estate in this world, except the one that is in France, except the one that is in Australia, or that is in Nigeria. So what I'm trying to say is that you have to be creative. You have to be creative in using the words that would lead to revocation when you find out that your client, who is an intending testator, has other wills in other jurisdictions of this world. And if you use this standard clause that we have here for revocation, that means that it will generally have revoked all the wills made in other parts of the world. But if you want to save all other wills in other parts of the world for your client, you need to be creative in, using the revocation clause or drafting your revocation clause. And I started an example for you that if the man has property in UK and it's only the will in UK that you want to revoke, you could say that, I revoke my wills to the extent that they relate to any part of my estate that is kept in UK. However, you could use this word to also revoke all your wills or all your wills, all your properties, all your wills previously made, so long as they do not affect the one in France. Look at this. I revoke all earlier wills to the extent that they relate to any part of my estate in any part of the world other than France. So look at those two examples, and then you see how to create, a suitable revocation clause in a situation whereby you find that, the testator is having wills in other jurisdiction. Of course, please, that having been said, let us note that the whole will may be impliedly revoked by a later one. We're talking about express revocation here. We're not talking about implied revocation. He said some of the time, the whole will may be impliedly revoked by a later one. Example will be where the wills are totally inconsistent, or where the latter covers the same ground. Where they cover the same ground, of course, what that means is that your will that you have made subsequently, will certainly have revoked the earlier will if the subsequent will is totally inconsistent with the earlier will, or if the subsequent will covers exactly or more grounds than the earlier will. So by so doing, it will be deemed that your will that is subsequently made has done what? Has revoked the earlier will. If it is inconsistent with it, or it has covered the same ground or more ground, it then means that it has impliedly, impliedly invoke the earlier will. It would be taken as a substitution for that earlier one. Of course, this document we are talking about will be read together. The document will be read together to ascertain the testator's intention of what should happen upon his death. So your first will and second will, which more or less are inconsistent, or which more or less covers the first, cover the same ground with the first one, will be read together in such a circumstance where there is no express revocation, where there is no express, term stating that you have revoked the earlier will, but you are implying you are revoking impliedly. When you revoke impliedly, what that means is that you have made a subsequent will which is either inconsistent with the first one or covers the same ground with the first one. And in that case, the court is saying that, or the authors are saying that, what court would do to come to a conclusion about the will is to put the wills side by side. They put the documents together to ascertain what is exactly the intention of that testator. What does he want? What does he wish that should happen at the point of his death? Now, see the case of Limage and then Goodman. In Limage and Goodman, Wild J mentioned that the will of a man, it says that the will of a man is the aggregate of his testamentary intentions, so far as they are manifested in writing. He said, the will of a man is the aggregate of his testamentary intentions, so far as they are manifested in writing. So they have to aggregate his testamentary intentions, so long as those things are in writing. When we are trying to find out, whether he has, impliedly, revoke his will, it goes further. That so long as they are manifested in writing and they are duly executed according to the statute. So the will of a man is the aggregation of his testamentary intention, so far as they are manifested in writing and they are duly executed according to the statute. So this is more or less in conformity with that statement we made earlier on, that the documents will be read together to ascertain the testator's intention of what will happen upon his death. And, while J in Limaj, and then Goodman is telling us that the will of a man is what? Is the aggregation of his testamentary intentions so far as they are manifested in writing and they are duly executed according to the statute. It goes further. He said, and so this court, he says, this court has been in the habit of admitting to probate such and many papers, all properly executed, as are necessary to effect the testator's wishes, to effect the testator's full wishes, and of showing, and of solving the question of revocation by considering not what papers have been superseded by the act of executing others, but what disposition it can be collected from the language of all papers, but were designed to revoke or to retain it. I repeat myself again. The will of a man is the aggregate of his testamentary intentions so far as they are manifested in writing, duly executed according to the statute. And so this court has been the habit of admitting to probate such and many papers, all properly executed as are necessary to effect the testator's full wishes and of solving the question of revocation by considering not what papers, they are not considering not just what papers, they are considering not what papers have been superseded by the act of executing orders, not what papers have been superseded, by act of executing orders, but what disposition it can be collected from the language of all papers that were designed to revoke or to retain. So they're saying that they don't consider what paper has superseded the other, but they want to look at what disposition could be collected from all the languages of the papers designed to revoke or to retain it. So that more or less aligns with what the author is saying, that the document will be read together to ascertain the testator's intention of what he wishes to happen after his death. And that is position in Limage and Goodman, where while Jay was telling us that it is the aggregation, the will of a man is the aggregation of his testamentary intention so far as they are manifested in writing, and duly executed according to statute, and that as far as court is concerned, they are always in the habit of admitting to probate such and many other papers, all that are properly executed as are necessary to effect the testator's full wishes and of solving the question of revocation. So, and then, what they do in that circumstance is to consider not what papers have been superseded by the act of executing another, but what disposition it can be collected, can be gathered from the language of all papers that were designed to either revoke or retain it. So they are telling us that there should be, to come to the conclusion about the will of a man in a scenario like this, there should be an aggregation of his testamentary intentions that are in writing and that are, duly executed according to statute. The court is in the habit of admitting to probate, so many of those papers that are properly executed as are necessary to effect the full wishes of the testator, and then in solving the question of revocation by considering not what paper has revoked the other by executing another one, but what disposition it can be collected or gathered from the language of all of those papers which are designed to revoke or retain the disposition. I repeat myself, and I summarize the quotation that we have read out here to state that the will of a man is determined by the aggregation of all of his testamentary, aggregation of his testamentary intentions so far as they are more or less manifested in writing and they are duly executed according to the provision of the statute. And also, the court is always in the habit of admitting to probate as many papers as possible, so long as they have been duly executed. And these papers more necessarily, if must necessarily, show the testator's full wishes, and then they have used this in solving the questions of revocation by considering not what papers have been superseded by the act of executing another, but what disposition it can be collected from all the languages, from the languages of these papers, that were designed to either revoke or, retain. So what I'm saying is that they don't look at what document has superseded the other. They look at the language of all of these papers seeking to revoke or to retain a disposition, and then they make a collection of what disposition could be made from there. So this is the position that I need to let you know. Now, the number 2 is implied revocation. Implied revocation that we have been talking about. It goes further to say us that a will without, being expressly revoked. How do I put this? I'm coming. 1 minute. Okay. What we are saying here is that when we talk about express implied revocation, it is possible that you have not revoked your will expressly, but you have made a subsequent will, and that alone would create a situation whereby your former will be revoked. So now, example of implied revocation that we have mentioned before will apply here. That when you make a will and it covers all the grounds stated in the earlier will, then you have impliedly revoked your will. Now, a good example of an implied revocation is seen in the case of Huxley's settlement. Huxley is spelled Hawksley. Put apostrophe before S, settlement. You put settlement. So they are saying that, there was a woman who made a will with a professional advice, and then later on in 1927, she made an homemade will, which did not contain a revocation clause. Now, what now happened is that it described, it described it in that homemade will as if, like, this is my last will and testament, and refer to the former one as the cancelled will. He said this new will is his last will and testament, and then refer to the earlier will as the cancelled will. That is Huxley's settlement. In that case, the woman who is testatrix made a will with a professional advice, and later on in 1927, he made an homemade will which did not contain a revocation clause. However, he described it by herself in that homemade will as a last will and testament, and referred to the former will as the cancelled will. Of course, the provisions of the latter will were wholly inconsistent. They were wholly inconsistent with the former will. And the court held that the phrases such as last will and cancelled will did not themselves constitute express revocation, but that the earlier will was nevertheless totally ineffective because it has been revoked by the 1927 will. So what I'm trying to say here is that when you want to revoke a will, you could do it expressly, which is by inserting a revocation clause, noting that there is a possibility that your revocation clause that you put here so widely could affect wills that is made by that testator in other jurisdictions, in foreign jurisdictions. So when you notice that that testator has other will in other foreign jurisdictions, you need to be careful and be creative about the will, about the revocation clause that you are going to insert in the will that you are drafting, such that you will not revoke other wills in other jurisdictions. So when you get to know that the man has, or the testator has other wills in other jurisdictions, it could be that you want to limit the revocation to a particular state or a particular country, or that you could draft in a way that you revoke all the wills in other countries except a particular one. So you need to be creative in that regard. We're not saying that now you could draft a will without putting express revocation clause there. And that would still amount to revoking your earlier will if any of these two things will happen. The first of them is that if the will, the subsequent will, kind of cover the entire ground that has been covered in the earlier will, then that means that the subsequent will has impliedly revoked the earlier will. If it happens that the subsequent will is inconsistent with the first will, then it means that the subsequent will has revoked the earlier will, as shown in the case. Oh my God. Okay. Hello. Hello.
Good
Hello.
morning, sir.
Okay, please, I'm back. My battery went off, so I think I was charging, but the charging port was not properly fixed. So now, please, I was hoping to finish this. I was hoping to finish this topic today, but as it is, we may not be able to. But we have to move fast. At least we need to take two more of the means of revocation before the end of this lecture. Now, I have mentioned to you that you could revoke impliedly if it happens that your will, the subsequent will, is inconsistent with the earlier will, or it has covered essentially what is stated in the earlier will. That would be a revocation. That Huxley's settlement case, what happened is that they are saying that merely saying that the new will or the latest will was his last will and testament, and that describing the earlier will as cancel will does not revoke the will. But what has happened there is that in the homemade will, he had made gifts that are virtually inconsistent with the 1927 will. So the subsequent will made by himself more or less, cancelled or more or less revoke the 1927 will, not merely describing it as, cancelled and stating that the subsequent one is more or less the last will and testament. But because the content of the homemade will more or less, was inconsistent with the content of the 1927 will that was made with professional advice, that means that the subsequent will that was homemade will more or less, revoke the earlier will made in 1927 with a professional advice because it was inconsistent with it. Now, you could also partially, impliedly revoke your will. If some of your provisions in the subsequent will are inconsistent with the earlier one, then that means that those ones that are inconsistent with the earlier one will prevail, and then the ones which are not touched, which are not, which the provision of the earlier one, which are not in conflict with the subsequent one, will still remain. So now, that having been said, Wills Act in section 20 is also saying that you could revoke your will, either partially, either partially or in its entirety without creating a new will or codicil. You could do that by making a declaration in writing, stating your intention to revoke the said will. So what we are trying to say is that revocation could have happened either expressly, by expressly inserting a revocation clause in your will, or by, or by kind of, revoking it impliedly, or, revoking it impliedly by making a subsequent will that is either inconsistent with the earlier will or which has covered the same ground. It could also be a partial implied revocation if your will is to some extent, not fully, inconsistent with the earlier will. That part of your will that is inconsistent with the earlier will revoke the earlier will, while the other ones that are not inconsistent with it will remain. We are also saying that, or we have also said that if your will is there intact, you could also revoke it by not necessarily making a new will or making a codicil. You could revoke it by making a written declaration stating that you intend to revoke your will. Now, remember also that codicil is basically a document similar but not the same thing as a will. Of course, in a number of jurisdictions, it serves the purpose of amending rather than, replacing what you previously have executed as a will. So what we're trying to say in essence is that your codicil could be used to amend your will rather than replace it. A subsequent will replace the other one to the extent that if it is inconsistent with it, or if it has republished, or if it has covered the same ground with the earlier will, it will replace it. But your codicil basically will not replace your earlier will. It can only amend to some extent. Of course, it is similar to wills, but it is not exactly the same thing as a will. Now, they are also telling us that this is also done by making an instrument complying with the requirement for making a will. I get to my point. And then, of course, what we're trying to say in essence is that you may not write a will. You may not write a will, but you could use other instruments, which is in writing, basically to revoke your existing will. Now, we have dealt with number one, which is either, which is subsequent will by will, subsequent revocation of will, revocation of a will by subsequent will of codicil. And then the summary of what we have said about revocation of will by subsequent will of codicil is that you can do it expressly by inserting a revocation clause. Now, with all of the variations that we have learned, you can also do it impliedly by making your subsequent will to be inconsistent with the earlier one, or to cover the same ground with it. You could also do an amendment to your will by, a written declaration, not necessarily making a will or codicil. Of course, you could also revoke your will partially and impliedly by making a will, a subsequent will that is inconsistent with some part of the earlier one. Some part of the earlier one that is inconsistent with this subsequent will be revoked. Of course, we also said that codicil could be used to amend your will rather than replace it. Even though codicil is used to replace, it's used to amend, it cannot replace it. It's only similar to will, but it's not exactly the same thing as a will. Now, I now said that the second method by which you can revoke a will is to use other instrument of revocation, which may not necessarily be a will. This is done by making an instrument complying with the requirement for making a valid will. It must be ascertained that the testator comply with this requirement. So when you make another instrument, not necessarily writing a will, to say that you have revoked your will that you have earlier made, then that instrument will still qualify as revocation of the will that you have made before. So now the third one is revocation by marriage. Revocation by marriage. This one is very crucial for us to listen to, and then we must understand what it's all about. Now, the rule is that, the general rule is that marriage will revoke a will, and that this rule that the subsequent marriage revokes a will is a long history that originates from common law. It's a very long history that originates from common law, and today it has been codified in statute. It has been codified in our statute. Now, note very importantly that while a will must be intentionally created, the curiosity about this position is that that will be involuntarily or unknowingly revoked. So it will be involuntarily or unknowingly revoked. Please hold on for me 1 minute. Please, I'm sorry. Let's go back to our business. Now, revocation revocation by marriage. You remember I said that it has a long. Are we together? Are we together? Hello? Hello?
Hello, sir.
Are we together?
Yes, sir.
Okay. Remember I told you that it has a long reason. It has a long history that is originating in, common law, and it has now been codified. That one curious thing about, this rule is that, of course, your will is made intentionally, and that the curious thing about it is that you could involuntarily or unwillingly or knowingly revoke it. Of course, the statement that can be made out of this rule is that if you make a will and then you subsequently get married under the act, that your subsequent marriage would actually invalidate or more or less revoke your earlier will. The essence of this rule is that it is to make sure that they protect the new marriage so that they will ensure that the children or child and spouse of this new marriage will benefit. Of course, what that does is that it will create an intestacy in the absence of a new will. So the point I'm trying to say in essence is that this rule we are talking about has a long history that is originating from common law, and that the curiosity about it is that even though your will is made intentionally, you could revoke it unknowingly and involuntarily. The statement that could be made out of this is that when you make a will and you have a subsequent marriage, that your subsequent marriage will certainly revoke your will. Now, that having been said, we are saying that the person that will benefit from that, that rule is the person who is married under the act. If you are married under the act, so the testator's marriage would automatically revoke any existing will or codicil. This revocation occurs by operation of law. It occurs by operation of law, whether or not the testator wishes or intends that such revocation should take place. It applies by operation of law. Now, unfortunately, not all marriage partners will be aware of this deemed revocation, and the law may occasionally be viewed as creating some hardship to the disappointed beneficiary. Not all partners will be aware of this. An exception to this general rule is made, and only if the will contains the specific declaration that it is made in contemplation of his marriage to a specific person. So now we are saying that when a will is made by a testator and he gets married subsequently, if that marriage is married under the act, then it then means that subsequent marriage would Hello? 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 Hello?
Sorry,
Hello?
I can hear you.
Okay. So now let's summarize this rule so that we can move on quickly. Now, the rule is saying that when you get married, when you make a will and get married, subsequent to that, a will is made. That will would certainly do what? That will certainly be revoked by that marriage. The essence of that rule is that is to cater for the new wife and the child or the children of that marriage. Also, it is telling us that basically for you to say that your subsequent marriage will invalidate the existing will, you must mention the name of that person, and then you must state that will is made in contemplation of marriage to that person that you have so mentioned. You must state the name of that person, I must also state that that will is made in contemplation of the marriage to that other person. However, they are also telling us that the people that will take advantage of, the advantage of, the person that will take advantage of a subsequent marriage, revoking the earlier will, are persons that are married to opposite sex under the Marriage Act. Please see the case of Martin and Christian. Martin is spelled Morton versus Christian. Now, the Nigerian case, the section of the Lagos State laws that will look for this provision is Section 11 of the Lagos State Wills Law and Section 3 of, or rather Section 13 of the Oyo State Wills Law. Check Section 11 of Lagos State Wills Law, or you check Section 13 of Oyo State Wills Law. Basically, what this one is saying is that one, the person must be married under the Marriage Act. Two, the marriage must be in contemplation to a particular person that is mentioned. The will must be made in contemplation of marriage to a particular person that is mentioned in that will. If that is the case, then that marriage would certainly destroy or revoke the earlier will, and then the essence of that is because it has a long history in common law, and then it has been codified in our statute. The whole essence of doing that is to make sure that the child or the wife of the marriage, they are benefited by virtue of creating an intestacy in their favor. Please note very importantly that the will must be made in contemplation of a particular marriage, and the testator must have been married to the same person, expressing that way. So apart from stating that this will is made in contemplation of my marriage to Mr. A or Mrs. A, then the marriage must have also taken place. Now, we also note that the name of those parties to the marriage that are contemplated must be clearly stated in the will. See the case of Jadesimi and Okotiebo. In Jadesimi and Okotiebo, it's a popular case that we all know. In that case, Okotiebo got married to Jadesimi in 1942 under the Native Land Customs. And then in 1947, he made the will in Sapele. Of course, the will was made exactly on the 21st day of August 1947. And then while the 1942 marriage under the Native Land Customs was still subsisting, Okotiebo in 1961 went ahead to go and marry his wife under the Marriage Act. Of course, in 1966, Okotiebo died in a coup d'etat, and then in 1971, the family applied for letters of administration. Letter of administration was granted, but subsequent to that, it was found that the man made a will in 1947, and the question now is that is this will valid? This 1947 will, was it valid? And court, in the High Court, the High Court led by Agoroje, ruled that the subsequent will, the subsequent marriage to Jadesimi by Okotiebo did not revoke that will, and then the Court of Appeal said no, by virtue of Section 18 of Wills Act of 1837, the subsequent marriage to Jadesimi by Okotiebo has revoked that will. But Supreme Court, led by Justice Waste, was of the view that the Wills Act, which is a statute of general application that we inherited from UK, should not have unlimited application. We should make them to be applicable to some restrictions. We should make them to do what? To be applicable, subject to some restrictions, subject to some circumstances that will permit them, and subject to our own federal law. He relied on Section 45 sub 2 of the Interpretation Act to come to this conclusion, that not all imperial laws shall be applied without limitation in Nigeria. We should apply them subject to our own local jurisdiction, subject to the circumstances that will permit them in our society, and subject to the federal laws that we have here. So the summary of the revocation by marriage is that one, if you make a will and then you have a subsequent wedding, that wedding would revoke that will, provided that you have stated that that will is made in contemplation of marriage to a particular person that is named. Also, if that marriage is made under the act, the essence of doing that is to make sure that the child or the children of the marriage or the wife, they benefit by creating an intestacy in their favor. Section 11 of Lagos State Wage Law makes this possible. Section 13 of Oyo State Wage Law makes this possible. And then those conditions include that it was made in contemplation of marriage to a named person, that marriage must have taken place, and that the names of those parties must be mentioned. Yadesimi and Okotiebo, like I mentioned to you, summarizes the position, and that, of course, what happens is that in 1942, Okotiebo married Yadesimi under native law and custom, and then in 1947, he wrote a will. In 1961, he went to go and have another wedding under the custom, native law and custom. Of course, when the man died under a coup d'etat in 1966, they tried to apply for letter of admission in 1971, which was granted in 1972. Subsequent to that grant of letter of admission, they found that a will had been made in 1947, and then the question now arises whether that will of 1947, has been invalidated by the marriage that was conducted under the Act in 1961. Agudo J at the High Court was saying that no, it was not revoked. It has not revoked the will. Court of Appeal, relying on Section 18 of the Wills Act, says that that will has been revoked. But the Supreme Court overruled the Court of Appeal, stating that we should apply the English law that is of general application, not in an unlimited way. We should not make them to have unlimited application. That, of course, what we should do is to make sure that, relying on Section 45 sub 2 of the Interpretation Act, we should try to make sure that imperial laws should have force, and then when they have force in Nigeria, there should be limits, and they should be limited to our own local jurisdiction and circumstances that will permit them, and they should be made subject to the federal law. Ladies and gentlemen, please, I'm sorry, we may not be able to go further than this today. We'll come to revocation by destruction with intent, and then the two other, the animus revocandi, and then presumption of revocation, and the dependent relative revocation when next we meet. Thank you very much for listening.
Good morning, sir. Good morning, sir. Good morning, sir.
Good morning. Good morning.
Happy New Year, Doctor.
Same to you. Same to you all. Same to you all.
Please, can you please take a question, sir?
Please do. Please do.
This revocation by marriage, sir.
Yes, sir.
If my understanding is clear, it's not the Marriage Act that revokes a will, but it's the person who now makes that will in contemplation of marriage.
Yes.
That is,
yes.
If a man
yes.
wants to marry,
yes,
if he has an existing will,
yes,
and he now wants to marry, he will put the name of the person he wants to marry in subsequent will. Am I correct, sir?
Yes, correct, yes.
Okay. It's not that ordinarily, because he got married under the Act, whatever will he had,
yes,
he must have stated in his will.
Yes, and the marriage must have taken place.
The marriage must have taken place.
Yes.
So, most likely, tentatively, or what I would say, it could be that in the case of Okotiebo now,
yes, that
he had maybe other wives and children when he made that will. Then he now married Yadesimi later dates. But the court, the lower court, the trial court, and the appeal court were trying to invoke the provisions of English laws.
Yes.
But the Supreme Court stepped in to say, no, we must recognize the peculiarities of our localities of laws.
Of our localities, yes.
Okay,
although
sir.
for me, I'm sorry to say, ordinary person may not get such interpretation from Supreme Court.
Yes,
ordinary person.
I know.
So that's my own sincere opinion. It's not a general one.
I know that case has been lingering. That case has been lingering.
For a long time, yes. So,
okay, sir.
But basic rule from which the court departed from is that subsequent marriage would certainly revoke a will.
Okay, sir.
All right. Thank you very much.
Thank you so much, sir. Happy New Year, sir.
You're welcome.
Yes.
Thank
Yes, yes.
you. Ah,
Yes, sir. Good morning, sir.
good morning.
Yes, sir. Please, I have a question. Concerning marriage. Concerning wills made in foreign countries.
Yes.
Concerning wills made in foreign countries, I'm not
Yes.
particularly sure, but I just want to understand the position. A foreigner in Nigeria cannot devise real property under a will, but is that correct, sir?
Go ahead. Finish your question.
Okay, but a Nigerian like if a Nigerian goes abroad and he devises his property abroad, can he like still abroad? Can he make a will that covers all his property like in other countries? Like let's say he's in Australia now. Can he make a will that covers his property in Nigeria, or does he only have to be limited to Australia?
No, he can make a will that covers all his will everywhere.
Okay.
Yes, it's
Okay,
possible.
but a foreigner cannot do such in Nigeria because they're not allowed to take real property. They're not allowed to acquire real property.
They are allowed to do that, subject to some exceptions that are applicable in our local jurisdiction.
Okay, sir.
Yes, sir.
Okay, sir. Thank you so much, sir. Thank you, sir.
All right.